Hello. Separate ecclesiastical courts to deal with matters deemed to belong to the government of souls were established in England after the Norman Conquest. In doing so, William the Conqueror was fulfilling a promise made to Pope Alexander II in return for papal backing of his invasion and his claim to the throne. These courts dealt with doctrinal transgressions and issues of morality, but also presided over divorce suits, validation of wills, and dealt with questions of legitimacy which strayed into secular areas. Additionally, ordained clergy charged with criminal offences could, by claiming privilegio clericali or benefit of clergy, opt to answer to a church court instead of facing a secular trial. A wise move because church courts never imposed the death penalty and acquittals were common. Typical of punishments that were meted out included being sent on pilgrimage or forced to make a public confession. Diocesan courts, known as consistory courts, were presided over by a bishop or their representative and applied canon law based on principles outlined in the New Testament, not common law based on custom and practice and statute law as in the secular system. Below the bishop's diocesan court was a more local archdeacon's court, and above them both the archbishop's court to which appeal could be made. The Archbishop of York's Court of Chancery normally convened in the Minster. The Court of Arches for the province of Canterbury met at St Mary le Bow, recorded in the 12th century as St Mary Archibus. The arches of the vaulted Norman crypt may be responsible for the le Bow or arch qualification. Church courts dealt with many cases brought by women. In civil courts, women didn't count as a legal entity, but in the eyes of the church they had souls, and in moral and spiritual affairs, where the soul was at stake, women mattered. Exemption from prosecution in the King's Court was extended in the 14th century to allow anyone literate enough to qualify for holy orders, although not ordained, to also claim benefit of clergy. Literacy was demonstrated by reading a passage from the Bible. However, it was invariably the same passage, the first verse of Psalm 51, known as the Miseria. In an English translation, "Have mercy upon me, O God, according to thy loving kindness. According unto the multitude of thy tender mercies, blot out my transgressions." Even in Latin, with help, not too difficult to memorise for a career criminal or anyone contemplating committing a felony. Offering a potential escape route from the gallows, it was dubbed the neck verse. Abuse of the privilege led to a one-strike rule that allowed a layperson convicted of a capital offence who successfully claimed benefit of clergy in order to receive a secondary punishment to do so only once. To monitor this, those convicted under the system would be branded, typically on their thumb, either with T for theft, F for felon, or M for manslaughter. Following the Reformation, the list of crimes for which benefit of clergy could be claimed began to be reduced. Not until 1706 was the literacy test abolished. Branding in benefit of clergy cases ended in 1779, but it was 1827 when the process ceased altogether. Before the Reformation, church courts dealt with divorce. Cases involving matrimonial causes could be quite salacious and attract a large audience. In order to obtain a divorce, it was generally necessary to find an impediment. Consanguinity was a common claim, that is, the couple were too closely related. This was the cause argued by Henry VIII in his unsuccessful attempt to get the Catholic Church to annul his marriage to Catherine of Aragon. Difficult for the Church to agree, since papal dispensation had originally been given to allow Henry to marry the widow of his brother, at the time a prescribed relationship. Other causes for divorce included insanity, heresy, and in an age when having an heir was important, impotence. The records of York Minster in the Borthwick Institute contain the case of Alice Russell, who brought her husband John before the church court, asking for the marriage to be dissolved on account of his impotence. To assess the truth of her claim, a jury of 7 matrons was sworn in and instructed by the court to take John to a room where a fire had been lit and food and drink provided. One by one they were invited to, shall we say, test his reaction. The poor fellow fails to rise to the challenge and Alice is granted her divorce. No surprise that church courts were widely known as bawdy courts. In the 19th century, involvement in divorce and probate transferred to civil courts. The main responsibilities of church courts today are in matters relating to church property and issues concerning the conduct of Anglican priests, church wardens and parish clerks. Next time, the General Eyre and the Royal Courts, the King's Bench, the Court of Common Pleas and the Court of the Exchequer. If you've enjoyed this video, hit the like and subscribe buttons and click on the notification bell to be informed when the next video is available, or you can subscribe by clicking on the rose window over my shoulder.